Hi, everyone. I'm Doug Kennedy. I'm one of the co-chairs of the Tort Claimants Committee in the Boy Scouts bankruptcy. And I'm assisted today by John Lucas. John is an attorney with Pacholsky, Stang, Zeal, and Jones, the law firm that has been representing the Tort Claimants Committee. We wanted to spend a few minutes talking about the trust distribution process and go through a series of slides, give some background, help to explain this better. The very first most important thing I have to say, though, and there's going to be a lot of important information today, is that this is highly technical, highly legal. It is a reason why the TCC has been saying since its very first meeting, I think, that we really encourage people to have legal representation. The TCC can't give you individual legal advice. We represent or advocate for all survivors, but we recognize that everyone's situation is individual and different. And it's a reason why you need to get legal advice from legal professionals. Having said that, we do know that there are people that do not have representation. So we thought it would be best to get this video out to help explain for those people maybe a little more so they can make decisions for themselves, and for everyone else so that when they have these conversations with their attorneys that they have a bit of an understanding also. I understand this a bit. John Lucas is much more the expert than I am on this, so I'm going to be asking him questions as he leads us through a series of PowerPoints. I've told John in advance, if I say anything that's completely off base or doesn't make any sense, please, please, please say so. He's not going to hurt my feelings because this is complicated. And I can tell you that if it comes down to this process getting confirmed, that I'll be having a conversation with my own attorney as to what makes the most sense for my situation. So I don't want anyone out there to think that you should automatically understand any of this because it's complicated. I should also mention that it is located in the, John, what are we calling this file on the website? Is it the, what plan is it? The third amended plan we have posted now?
So the plan that's on the table is the third modified fifth amended plan of the Boy Scouts of America. And this is Exhibit A to the plan, which is the trust distribution procedures. And I wanted to reiterate also that I agree with Doug that getting legal help is really important, because what Doug and I are going to go through isn't all the answers. It's a high level overview of the trust distribution process. And most importantly is that everybody's claim is a little bit different. And so it's hard to answer claims generally when the specifics of your claim, of Doug's claim, might be different than the specifics of somebody else's. And so we're trying to provide sort of general overview of more of sort of the process of things that you're going to have to do. And some people might have to do more, some people might have to do less, or some people might have to do things that are just wholly different. So.
Right. And the TCC is not advocating for any one path in this. We respect everyone's individual choices about that. We just want to be in the business of getting out the best possible information so you understand it a little bit better. So John, why don't we go ahead and start in on the slides that you've prepared.
There we go. Doug, are you going to start it off, or do you want me?
Well, yeah, no, you go ahead and start this off. But just to reiterate to everyone, we're trying to address the issue of these three paths to have your claims reviewed. And there's been, unfortunately, the sort of headline that came out was, you know, this $20,000 path that people were going to have to pay. And it's not entirely the case, certainly for everyone. So we're going to get there. We're going to get to the $20,000 question, but we want to be able to review this top to bottom.
Yeah. And so as you see here, there are three ways to have your claim reviewed, and we'll go through each of them. The expedited distribution, the sort of the general trust claim submission process, And then the most recently, what everybody has seen, what's called the independent review. And so we'll start with the expedited distribution. And, if those are so inclined and you want to look in the trust distribution procedures, this is in Article 6. And here, an overview. This is where a survivor has elected on his or her ballot that they would like to take the expedited payment of $3,500. So you have already done this on your ballot, or you have until March 7th at 4 p.m. Eastern to make this election on your ballot. And this is the only time that you could go this path, is by making the election on your ballot.
Okay, John, so that's my first question. If the survivor starts looking at this plan and this video and says, you know what, I didn't elect the $3,500 before, but I want to now. So one of the things you're telling us is that they have to make that change.
Yes, and if you're represented by counsel, work with your counsel to get a new ballot to make the change on your ballot. If you aren't represented by counsel, you can get a new ballot by emailing the voting agent, Omni, and you can go to www.tccbsa.com, which is the TCC's website, and there is information there, step-by-step information on how you get a new ballot.
And John, if I elected the 3,500 before and I changed my mind, can I unelect it now?
Yes, you can.
Okay.
As long as you do it before March 7th, 2022 at 4 p.m., not postmarked by that date, but it needs to be in Omni's hand by snail mail or uploading it through the web.
Okay.
And so here are some of the other sort of general requirements. You need to have signed your proof of claim yourself. And so if your attorney signed it for you, then you need to amend your claim and sign the claim yourself. The March 7th deadline isn't a requirement there, but you must do this here. You should do it as soon as possible. The proof of claim must be substantially complete, and no other information is required. If the expedited distribution whole process, once it's complete, you'll be required to sign a release, which releases all the other parties from any liability. And this is your final payment. You will not receive anything else from the BSA distribution process. It's a one-time lump sum payment of $3,500. So, all right, we'll move on here to the regular trust claim process. And here's sort of the flow chart.
Yeah, let me interrupt. Let me stump your toes for a minute, John. What we're going to do is, for each of these sections, we're going to provide just a little bit of a flow chart, and then we're going to go into each of these blocks a little bit more in detail as well.
Yeah, and we'll put these slides up on our website too. So here we go. This is in Article 7A of the trust distribution procedures. And the first part here is just sort of the general overview. The plan has been confirmed or approved by the Bankruptcy Court, and it's effective. And so all the assets have moved to the trust, and the claims are in the trust, and the settlement trustee and the claims administrator, and everything is up and running.
And let me interrupt, John. And it's, when we're doing this, it's February 22nd right now. There's a confirmation hearing, and we're going to have to see what happens in the confirmation hearing. So some of this could be subject to a little bit of change on dates and some other things that are happening. So please continue to check back on the TCC's website and check with your attorney if you have one, because what we're saying today might not be the case in a week or two or three.
Yeah. So under the trust distribution procedures, you need to have timely submitted a proof of claim. And then there will be a claims questionnaire that is created and distributed by the settlement trust. And so that hasn't been done yet because the trust isn't up and running. But the settlement trust will ask questions that will be sort of modeled on your proof of claim, but perhaps asking for additional or some different information that isn't included in your proof of claim. Your claims questionnaire must be signed by you, the survivor, or your executor, the executor of the survivor's estate. And then you will be asked to produce any available documents or records that are relevant to your claim. So, I mean, if you have the documents and you have stuff that supports your claim, it's only going to help you and the claims administrator sort of evaluate your claim. If you don't have anything, then you don't have anything, and perhaps you're going to maybe provide some other sort of written record or summary of what it is that happened to you. The trust might require an examination by a healthcare professional, or a written or verbal examination under oath, to ask questions to better understand when your abuse occurred, what had happened, and the effects on the abuse since it happened.
And that's may require. It's not any kind of guarantee. And John, let me just also ask this question. You mentioned that the trust is not yet set up. All this happens after as part of confirmation, but safe to assume that it's going to take a couple months for the trust to kind of get this questionnaire together, get its operation going. So it's going to take a little while until survivors see any of this in their mailbox. Is that right?
That is certainly true. The trustee and the claims administrators will sort of be opening sort of a small little operation, if you will. And so as a result, a website will be created. So they'll have staff and other claims reviewers to help them sort of undertake the whole process. The settlement trustee will have to come up with the claims questionnaire and have it modeled and maybe tweaked and have their counsel look at it and stuff. So it won't be an overnight thing. The trust won't be created on day one, and this stuff isn't going to start on day two. It'll be could be 2 or 3 months here before the trust is up and running.
Right. And one of the things you had mentioned from other bankruptcy cases is it's pretty standard procedure at this point for the trust to set up a website, a portal, a way to keep claimants, in this case survivors, updated as to what's going on and what to be on the lookout for.
Sure, I would expect that. That will be entirely up to the settlement trustee, but I would think that they would do that. The claims questionnaire would probably be posted. There would be relevant dates and deadlines on the website, and in a way in which you could either, where to send your documents, or a way in which you could upload your documents that are specific to you. And then here in the bottom, it's really important that if you did not submit a claim questionnaire, or you were asked to sit for a written or a verbal examination under oath and you refused, then those can be complete sort of bars, if you will, to any distribution. The trustee will have the ability to disallow your claim if you're not following through the process and submitting the information to the extent that you have it, that he or she is looking for. So let's move on here to the next page. And so again, general requirements: proof of claim and the claims questionnaire. And the claims questionnaire is going to ask for other information that you might not have otherwise submitted with your proof of claim. And the general criteria that the trust is going to be looking for is that you identified the alleged abuse, that you identified the abuser by name or physical description. You need to show that there's a connection to scouting, that this happened at a scouting type sanctioned event, and that the date, your age, and the location of the abuse. And all those things are the sort of the general sort of requirements that the trustee is going to be focused on.
John, one of the things that we're hearing from survivors is sometimes, this happened to a lot of us a long, long time ago, and things like the date, for example. People might know I'm like 7 years old, for example, or I guess maybe that. So my question is, these sort of general requirements, these are the things that the trust is looking for, but certainly survivors are going to be able to provide as much as they can in this case. None of these are going to be something that's going to disqualify you if you don't have them, in other words.
No, I wouldn't say it's going to disqualify you, but everybody needs to remember that the more information that any survivor has, it's going to help support his or her claim. And so, for example, if somebody can't say, like, I don't know where it was I was abused, then, the trustee is going to take that into consideration. And that could be something that sort of weighs in his or her decision on to what the award might be if the person can't remember where it was.
Okay.
And so, they will be factors. All these things are factors that the trustee will consider, or the claims administrator will consider, in evaluating the overall claim award. And when that happens, there's a matrix that is in the TDP, or the trust distribution procedures, and the abuse claim evaluation starts at a base number. And there's a chart that's in the TDP, and it gives the base number for each type of abuse, or sort of the level of abuse, if you will. And that's where it starts. And then from there, the claims administrator will apply scaling factors to increase the amount of the claim or decrease the amount of your claim. And so the information that's in your proof of claim, the information that's in your claims questionnaire, or other information that you provide, or in a written deposition or an oral deposition, all that information will help the trustee and the claims administrator apply what we call aggravating scaling factors, which can increase the amount of your claim, or mitigating scaling factors, which can decrease the amount of your claim. So, a lot of times people might say, well, what's going to increase my claim, or what's going to decrease my claim? And, naming the full name of your abuser is something that's going to help increase your claim. Identifying that your abuser was in Scouts, and that maybe there's a roster that can be produced that shows that your abuser was in Scouts. Maybe identification that your abuser abused multiple other survivors. I mean, those are things that will help, what are called aggravating scaling factors that will increase the award.
And John, this is to a large extent going to be the work of the trust to not only collect all this information, but it's important for survivors to know that they're going to be responsible for validating it as well. So,
well, when you say that, so I want to say that it's more on the survivor here. I mean, the trust can only do so much. It only has what it's given. And so, that's why we think it's important that survivors get counsel, because counsel will sort of help excavate, if you will, or maybe help a survivor sort of maybe try to locate some of these documents, or, for example, like the rosters, for example, to show that your name is on a roster for a certain local council in a certain region, or that your abuser's name is on an adult roster at a certain region, a certain local council, and you were both there at the same time. And so the trust is only going to have sort of what it's given, and the trust isn't sort of going out and turning over rocks and looking for things to help you with your claim. I mean, the trust is there to evaluate the information that's given to it.
Right. So it's the responsibility of survivors to not only provide the information as well as they can, but sort of document that it's valid as well, is what I hear you saying.
Yeah.
Okay. I should also mention that I did a little multitasking here. If you go to our website, tccbsa.com, under files, you'll see the trust distribution procedures is a separate file, and that's where the matrix and this information is. So it's posted on our website now if you want to do a deeper dive into what the matrix is, for example.
And thanks, Doug. And then everybody needs to remember that, another scaling factor is that if your claim is subject to a statute of limitations, then also in the TDP on the last page, there are statute of limitation scaling factor, which will decrease the ultimate award. And so if you're not in a state that's an open state, then there will be a discount that's in a range that the trustee or the claims administrator will select for each claim. And then last here, which is also really, really important, is that right now there's a certain amount of cash and assets that are in the trust. It's like approximately $2.7 billion, which is just a staggering amount of money. But given that there are over 82,000 claims, that there might not be enough money to pay everybody the full amount of their award. And so as a result, if your award is, as an example, $250,000, and there's only enough cash in the trust to pay 20% of that, then you're going to get $50,000.
And John, there are a few things, and that's never good news for any survivor. The reality here is that there's right now a finite amount of money, and there will still be work to continue to make settlement with other parties. Is there a possibility, because of course the trust has to also reserve money for its own operation as well, is there a possibility that as settlements are made, that additional payments can be made to survivors that have already received awards?
Yeah, so two things on that, Doug. That's a great question. Number one, the trust has 2.7 in it now in cash and assets. There are other insurance carriers out there that either the debtors before confirmation or the settlement trust after confirmation is going to want to get contributions from. And so we hope and expect that there will be cash contributions in addition to what we already have into the trust. There are also chartered organizations out there that won't be covered by the channeling injunction under the plan if it's approved. And so if those chartered organizations are going to want protection, then they're going to have to pay for it. And that money will also go into the trust. And so then the third thing to answer, I think, your really direct question, Doug, is that I would expect that the settlement trustee is going to try to evaluate claims as soon as possible and start evaluating them on a rolling basis. And so if your claim is, let's say the ultimate award is $200,000, I could see the trust making an initial distribution on the claim of just a portion of your claim, because the trust will need to hold back cash because it's not going to exactly sure how much money it will have in the end and what the sort of evaluation of all the claims will be. And so you could get a distribution, maybe, let's say 6 months into the evaluation process, and then you might get another distribution a couple months after that. And then maybe at the end of the process, you might get a third distribution, so that once all the money gets pushed out and then where the trustee knows where everything is. And so there could be more than one distribution on your claim.
And John, this is probably a good time for us to mention first in, first out. Would this be the right time?
Yes. And so under the trust distribution procedures, that there will sort of be a line. And it isn't, the date or the time that you filed your proof of claim, but those that get in their claims questionnaire in first in all the supporting materials will get put in a line. And so the sooner you get your claim questionnaire in, that's the time and the date in which the line in which the trustee and the claims administrator will evaluate your claim. So, and remember, the claims questionnaire does not exist yet. The trustee and the claims administrator will create that, and you will get some sort of notification of it in the future once the trust is up and running. So it's not there yet. Let's see here. Reconsideration, Doug.
Okay, so this is an important point. And I think for a lot of survivors, John, they were, because of some headlines, were under the assumption that, wait a minute, the only way I can have somebody look at my claim again if I'm not happy or have a higher level of sort of review is if I pay a large sum of money. But the reality is the majority of survivors we anticipate will be going through the trust distribution path, and there's sort of a built-in review that's already in it. Would that be a correct way to phrase that?
Yeah, there's really sort of two paths, or I should say there's sort of two stops on the same path. You go through the process, the trustee and the claims administrator determine your claim is worth $200,000. And then you look at it and you think they made a mistake, or actually they didn't consider these 3 things that I should have given them, or it doesn't look like they consider these 2 things that I did give them. And you think that if there's some sort of better support for your claim or some advocacy on part of your claim, that if it went through the process again, that you do better. And so you're free to do that, but there's an administrative fee of $1,000 to do that. And that is to help the trust absorb some of the cost of having to sort of go through or redo part of the process of which it already did one time. And so if after the review process, you're still not happy with the result of your claim, then you could sue the trust in a court, not the bankruptcy court, to determine whether or not the settlement trust award was reasonable. And again, that will all be all on you. You'll have to do that, hire counsel or do it yourself, but all the costs and expense of doing that and taking the trust to court will be on your shoulders.
Okay, so the bottom line here is if I receive notification of an award and I say, hey, I've got additional information, or somebody didn't look at it closely enough, or I just want another set of eyes on it, then that review is $1,000 fee. And if it turns out in my favor, then that sort of is refunded at that point.
Yeah, 2 things. And so once you do receive notification of your claim determination, then you have 30 days to consider whether or not you want it reconsidered. And if you let the 30-day period expire, then you're stuck with whatever it is that the trust determined. But if you do want it reviewed and you submit the $1,000 fee, and then the trust comes back and agrees that your claim should have been something different, better, increased, then the $1,000 fee is waived.
And John, what about if I have reconsideration and for some reason the trust says, actually, it was our mistake, you should be getting less, then that's a binding amount, isn't it?
Yes, it is. It is.
Okay.
Yeah. So there's risk and reward there on a couple different levels.
Okay.
So here's the next path, or the final path for a claims review. And this is what we call the independent review option. And we will sort of go through this flow chart here on the following slides to explain to everybody how this independent review option works.
And this is the $20,000 option that everyone has been sort of most focused on. And I think one of the things we want to do is try and explain not only what we just explained, which is that the trust distribution process is already sort of meant to give the right review, but also why this one, A, costs a lot of money, and B, is really designed to be used for outliers more than anything.
Yeah, and the other important thing too, before we start, Doug, is that the process that we just went through, that's all built in. You're not required to do the independent review. There's no requirement. You don't have to go this path. It is up to you whether you want to go this path or you want to stay in the other thing. And so you're automatically in what we call sort of the general TDP or trust distribution process. And to go in the independent review, you need to sort of actively elect into it, and you're not required to. So here's an overview, and this is all laid out in Article 13 of the trust distribution procedures. So you'll need to make an election in connection when you submit your claims questionnaire, and you have to do it within 6 months after the plan becomes effective.
Okay, so that's important. As a survivor, I can't go ahead and get my award and then decide, just kidding, I want to go independent review. I have to decide this beforehand.
Yeah, and you need to do it within 6 months after the plan comes effective. And that's really important. So if you wait longer than that, then you're just in the TDB process, in the regular process that we just discussed earlier. But, and so here, this provides sort of a process to have a neutral third party provide sort of a settlement recommendation to the settlement trust. And, The base and maximum matrix, which we talked about in the last process, doesn't apply to this. And here we really, really stress that before anybody considers this option, that you consult with an attorney before pursuing this option. It is just essential. This is like going to court.
So John, when you said the base and maximum matrix, that means the numbers that are in the matrix now, but the maximum award can only be something that's a function. There is, isn't it 5 times what the maximum is? I know I'm getting complicated here, but when you say the base and maximum matrix does not apply, what this means is that this process is outside of the TDP matrix. Isn't that what we're talking about?
It is. You know, there is a ceiling on the amount that the neutral can award, but the neutral isn't wedded to a base amount and working with the scaling factors. This is more sort of similar to filing a complaint in court, collecting your evidence, and advocating for your claim about, you know, why your claim should, you know, be X plus Y instead of just X.
Okay, so, you know, on the high end of that, I think, isn't it correct that the maximum would be something like 13 million, but it's important to say that there's also the minimum could be 0 too. So a neutral could look at this and say, sorry, in the court of law, this wouldn't hold up at all. So it's worth 0. Isn't that true?
That is exactly correct. The neutral could come back and the neutral could say, yes, I think your claim is not worth anything. Or I think your claim's worth $100 or $1,000 or $5,000 or some small amount. And once you're in this process, that's your claim and that's what you're wedded to. So as Doug and I were saying here on the last slide, it's a detailed review that's meant to replicate the presentation of your claim is if it was filed in court. And so there will be somebody who's experienced at evaluating sexual abuse claims, perhaps a retired judge. And, you know, like before, if you're not satisfied with the settlement recommendation, you can go to court to have them determine whether or not the settlement recommendation was reasonable. And so let's say that the award, hypothetically, is $3 million. What happens here and how the claim is paid is that the first $1 million of your award shares in the available cash that's in the regular trust. So right now there's about 2.7 billion in cash and assets in the regular trust. And so you would share in that cash.
Okay.
Yeah, go ahead, Doug.
So let me stop you for a second, just so we're all clear on this. So what that means is that, let's say the neutral says, well, your claim is worth $4 million. The first $1 million comes out of the trust, but only to the percentage that all survivors are receiving. So if all survivors are receiving, say, 20% right now, and we're just making these numbers up, 20% of their award, then that would also be true of this first $1 million as well.
That's right. So I mean, let's say that there were 5 survivors and they each had $1 million to go towards this part of their claim. So they have 5 $1 million claims. And let's say that there was only $1 million to share with them. They would each get $200,000, even though their award in this part of the claim is $1 million. They could only get to the extent that there's enough cash to pay them. And so everybody's going to share in it sort of equally.
Okay, so that's an important takeaway, John. While the amount that you get might be more than the matrix value in the TDP, you're still going to be getting the same sort of percentage of all survivors on available funds.
Correct. Correct. And so, but the part that's in excess of the $1 million, so it was a $3 million claim, $1 million goes to the TDP, and then $2 million of it goes to the excess fund, which is going to be funded from settlements with the excess insurers. And it's really, really important that everybody understands that as things stand right now, there are no settlements with excess insurers. And so right now there's no cash in the excess fund. And so there's no money to pay claims that go through this process yet. So we hope that changes, and we hope that between now and confirmation, potentially there could be a settlement, or more likely after confirmation, there could be a settlement with a settlement trust and an excess insurer, and that money would fund the trust, or it would fund this part of the excess fund of the trust. So this is, what do I need to do? I mean, this is one of the questions that I receive most, Doug, and I'm not sure about you, but what is it that I need to do once I'm in this process? And again, proof of claim that's signed by the survivor, that it's complete, that everything is filled out, all the details there, and you have a narrative that describes your abuse and what happened and when it happened. And you need confirmation that you were in scouting. You were a scout, and you could demonstrate this by a roster or a membership card or a photograph or a sworn statement by a witness that says that you were a scout.
And let me interrupt you for a second, John. So again, I think it's important to remind everyone that this process is supposed to, or trying to, kind of mimic what would happen in a court of law, where it's more than filling some forms out. It's this neutral really has to look at evidence to mirror what would happen if our cases had gone to court. Is that correct?
Yeah, I mean, and to be clear, I think that the claims administrator in doing the regular TDP process is going to be looking at evidence just the same here. But I think that this is, I think that the review and the sort of the amount of information or evidence that might need to be supplied to support this type of claim is going to be very, very, very important. And so again, there isn't any formula as to what it is that you have to show that you were a scout, but it has to be something that the neutral is going to believe. And so the same, that your abuser was in scouting, the abuser's name is on a roster, there's a photograph or some sort of sworn statement or other document that shows the participation in scouting. Your abuse claim, it must be in statute. It can't be out of statute. And so again, this is crucial, because if you're in a court of law and your claim is out of statute, the defendant is going to come and it's going to move to dismiss your case because it's going to say, hey, the claim wasn't filed in time. And so that's going to be an important component of the process. And you're going to have to demonstrate that the Boy Scouts, a local council, or a chartered organization was negligent, as a court would determine this. And so
and I should jump in, because I had questions about this that I asked John and a couple other attorneys about it. And negligence is a legal principle. It's a legal term. There are defenses to negligence. There are definitions of negligence. So it's really why we suggest and implore people to consider and chat with an attorney who's skilled in these cases to really get a sense of whether or not they're going to be able to clear some of these hurdles.
Yeah. And then, and then part of this here in the end, you're able to sort of demonstrate, the things that we've been talking about. Then you're going to have to demonstrate that you were injured or damaged. And, that's another sort of, I think, legal requirement that I recommend hiring and being involved with counsel to help demonstrate that. And, but most importantly, again, and this is what Doug and I said at the beginning of this video, is that this is an overview. Just because you've sort of hit each of these bullets here and you've satisfied, hey, I was in scouting and named my abuser and he was in scouting and my claims in statute. I mean, the fact that you checked each of these boxes doesn't guarantee that you're going to get an award, or that you're going to get an award that's more than $1 million. These are just minimum requirements to sort of get you in the door so that the neutral can begin evaluating. So let's talk a little bit about the administrative fee, Doug.
Yeah, this is the one that's gotten everybody's attention, and there is some logic to it. One of the things that we've heard is that this is really penalizing people that can't find that money, and it's kind of the cost of entry, but there's a little bit more going on here than that.
Yeah. I mean, one thing that's important to realize or to recognize is that if you were to take your claim now and you were to go sue the Boy Scouts, or you were to go sue the local council or a chartered organization, or all three of them in some court that isn't free. Yes, your attorney might be doing it on a contingency and is going to get paid a percentage of any award that you get through the court. But during that whole process, from the beginning of having to file the complaint and all the costs and the fees that go along with that, depositions and all the costs and fees that go along with that, hiring experts to help sort of support how you were injured or damaged. All of those things there will cost money, and they cost your attorney money, actually, really, that will come out of your award. And so if, just as an example, if 20,000 survivors were to elect to go through this process, it would cost the trust at least $400 million just to run the administrative hurdles to go sort of through each of these independent reviews. And so there's a limited amount of money that's in the trust. And so if survivors are going to want to go this route, and they're not required to go this route, then they're going to have to put in the money to offset the cost for the trust, because otherwise we're basically taking the money that's to pay other survivors and using it to sort of run this review process when they might not even elected to go through it, and it's not even going to benefit them.
Yeah. So John, let's just stress that for a minute. And that is, the monies are going to offset the cost of the review. And if people applying for that review aren't paying for that or paying a large portion of it, it's going to come out of everyone else's pocket. And I'll have something to say about kind of the purpose of all of this, but what we're trying to do is we're trying to spread this money out as best as we can.
Yes, absolutely. And so, it isn't 20,000 right off the bat. It is an initial fee to start the process is $10,000. And as you, and hopefully you and your counsel are conducting what's discovery, which is trying to collect additional information to support your claim. And let's say that you look at the information and you look at it and you're like, it's not what I thought it was going to be, or I don't have as much information as I thought that I was going to be able to support my claim. Then at that point, you could just say, hey, you know what? I don't want to do the independent review anymore. I want to just go back into the regular TDP. And it was just $10,000 to get you in the door. But if you want the neutral to evaluate your claim after you've conducted your discovery and submitted all your additional information, then it will be required to pay another $10,000. And so in there, and as Doug and I said, this is to offset the huge administrative expense burden that the trust is going to bear for each and every person that's going to do this election. And in the end, that the administrative fee can be waived by the settlement trustee under certain circumstances, but that will be up to the settlement trustee to determine on a case-by-case basis. So, and that's it, Doug. That's the end here.
So I took a couple notes, John, and you may have mentioned this, but let me bring it up again. Two things. One is the 12-month. You can wait 12 months to make a decision about part of this.
Yeah. So, right at the beginning, you submit your claims questionnaire, and let's say that you're in a state and the legislature in your state is considering opening a window and renewing the statute, or open it so that your claim won't be out of statute anymore. I mean, I want to say that during the Boy Scouts case, Arkansas, Colorado, Louisiana, or just I think 3, maybe even there were a couple others that opened statutory windows during the Boy Scouts case. And so something like that could happen after the plan is confirmed or approved. And so you might want to say, hey, settlement trustee or claims administrator, here's my information, but I want you to sit on my claim for now. And you have like a 12-month window to do that because you think that your claim could be reviewed in better light if the statute is renewed.
And then my other question is, we talked a little bit about first in, first out, but what happens if we have a survivor that is in poor health? Is there a way for the trustee to maybe consider that person's claims a little bit earlier?
Yes, so there is as thanks, Doug, that's a great point. There is a first in, first out. The first one to get their claims questionnaire completed and all the information submitted will be the first in line to have the claims go through the claims review process. And the trust will adhere to that process, except for circumstances where a person might be in poor health or other exigent circumstances that might require some sort of expedited review to sort of take the claims out of order.
So one of the things that the TCC is going to do is once a trustee is named and that operation gets up and going, is the TCC is going to communicate with the trustee and really make it clear how important communication is. We've held now almost 30 town halls. We have a website. The trust is going to have to communicate in whatever fashion they think is going to work best with survivors. So we know there's a lot of anxiety out there, people literally checking mailboxes. We want to make sure that people are going to know what's due when and where the trust is in the process. A few other takeaways.
Hey, Dick, I just want to tweak one thing that you said there.
Please.
We have a little bit of a chicken and egg thing here. So the TCC will do its best to keep survivors up to date as this process unfolds. But the trust itself and the trustee and the claims administrator won't assume their roles until the plan is confirmed or approved, and then it goes effective. And then when that happens, actually, the TCC will be gone.
Right.
But as we said, we could expect that the settlement trustee and the claims administrator will have a website and will provide updates, and there'll be information on the website for you to sort of guide the process forward. But to the extent that we can, we will try to paint a path and sort of lay out as much information to the extent it's possible before that time comes.
Thanks, John. It's an important distinction to remind everybody that, and the TCC is very concerned about who's going to be advocating for survivors if all of this is confirmed. And that's why we want to be able to communicate that to the trust. We've been at this now for over an hour. It's complicated. We hope that this will help to explain it a little bit more. No one wanted to be in this position. No one wanted to be trying to figure out how best to allocate the money that's there. In an ideal world, none of this would have happened. In an ideal world, there would be enough money now to pay off all claims at their maximum value. So more than anything, the TCC wants survivors to understand that we're trying to come up with a process that it follows what's happened in other mass tort cases, that one that will be sensitive to the individual needs of survivors, will allow them to have review at different levels that they feel is appropriate. And we just want to be in the business of education and explaining this process. I should tell you that we will continue to communicate as best as we can. If you go to the TCC website, please, tccbsa.com. We'll post information there as well. There's a link to where you can email questions. I have to tell you that a lot of those questions are very, very individual, and the responses from our professionals are going to be to encourage you to talk to counsel about your situation, but they do help to inform us as to what the questions are, and we'll continue to answer them as they come in. And John, thank you very much for putting these slides together and helping to explain the process, and I'm sure we'll be talking about it a little bit more as time goes on.
Hey, can I add? Thank you, Doug.
Please.
No problem. And just one other thing, about submitting questions on the website at tccquestions@pscjlaw.com. If you're represented by counsel, we're not going to respond to your question. You need to contact your counsel and have your counsel contact us. And we're happy to answer any questions through your counsel that your counsel can't answer to you. So,
Thanks, John.
yep.
All right, everyone, that's the update. Hang in there and stay strong.